national treaties to address what would essentially be the root causes of the building of the stereotypes that lead to the violence, and helps to undermine efforts to stamp it out and to address it even within national legislation. Which leads us very nicely to Gaietry Pargass, who is a legal consultant. One of her areas of focus is the development of policy and legislation to safeguard the rights of women, children, workers, and persons living with HIV. She has worked closely with the process of developing domestic violence legislation for Trinidad and Tobago, the 1991 legislation, and more recently, the review of the existing 1999 Act. Gaietry.
Thank you, Elizabeth. That'll give me 1 minute extra. Good evening, everyone, and I will try to do some justice to my part in 10 minutes. And I think Elizabeth summed it up very nicely when she said that both Levi's and Veronica's presentations lead very nicely into the little I have to say. And the first question, having listened to them, which all of us should be asking then, is how can you structure law to deal with such complex issues? Law generally deals with harm, and the law is trying to rectify harm. But what is causing the harm is what Levi and Veronica have been speaking to. Multiple masculinities giving rise to different forms of harm by way of power, control, and coercion. The topic really encapsulates that very question. How can the law respond to such a complex issue? How can the law both deal with the harm and what is causing the harm? And who indeed crafts the law? Who makes the law? And how is all of that understanding to be reflected in the law? And therefore, to what extent can the law be useful, be helpful, be an obstacle? How can the law act as a tool to dealing with this issue? And it isn't only limited to gender-based violence. When you look at all the other kinds of violence, murders and those kinds of issues, yes, the law is dealing with the harm, but what often fails to be reflected is that the law is dealing also with performance of masculinities. Because murder, and many of the kinds of murders we witness, whether it be murders in the home or murders outside of the home, they are performances of masculinities, as Levi was speaking to. So very quickly, what is the legal framework, bearing that in mind, what is the legal framework in Trinidad and Tobago for dealing with gender-based violence? I'm extending it to beyond domestic violence because they are so inextricably connected. And we have physical and sexual violence being dealt with in the criminal law. The criminal law addresses that kind of harm. We have the Sexual Offences Act 1986, the summary offences and offences against a person. The latter two date back, many, many decades. And at that time of crafting the law, the issues of gender-based violence, violence driven by power and imbalances of power in relations, did not even lawmakers were not even addressing their minds to those issues. They were dealing with the pure harm. When it came to a little bit later, the Sexual Offences Act 1986, it sought in some way to modernize the law and to imbue the law a bit with an understanding of what drives the law. But even if one imbues the law with that kind of understanding, the end product and what happens and how it is acted out, as we will see later if I have time, says a lot. So who are the main actors in the criminal justice system that will be dealing with gender-based violence? Bearing in mind that gender-based violence, the majority of victims would be and are indeed females. We have heard, yes, there are males, and particularly young children, young males, who are the receiving end of gender-based violence, but generally, women are the majority, women and girls are the majority of victims. And who are the major actors in the criminal justice system dealing with this kind of violence, which is harm plus? The police, primarily, they are the first line responders. They receive reports, they investigate and lay charges. The judicial system, which are the magistrates' courts and the high court. And so they are the police, the magistrates, judges and lawyers, as well as other persons who are in support services, are the major actors. Many of these persons, no matter how the law was conceptualized, how the law was framed, many of the major actors are not thinking along those lines. They have not been necessarily sensitized to the issues of gender power imbalance, of the performance of masculinities. And so when they receive the report and there is insensitivity or ridicule, or when it gets into the court and the court may make a statement that is totally gender insensitive, and when it may lead to a particular outcome that is along that spectrum, one can well understand why, as Veronica is saying, there is such a disconnect, because what are the limits of the law? How can the law be stretched and become malleable enough to deal with such complexities? And perhaps that's an impossibility, because the law does indeed have its limits. Okay, so what is then, therefore, the adequacy of the criminal law? How can victims access justice in Trinidad and Tobago? And this has not, as we are speaking, and even what has been in the public domain in the recent past, quite frankly, the criminal law has not received much attention. It's rarely in the public domain. Domestic violence, much more so. And so if we do not speak about it, if we do not engage in discourse about it, it becomes hidden, it gets on the back burner, and nobody is thinking about whether the law is indeed.
She will get an extra minute, but she may. You know, the other,
yes,
what else you haven't said will come out in the questions. So maybe.
Okay. So indeed, it is fairly opaque. Police and attitudes and responses, as I've already said. The statistics are woefully inadequate. The cases are not tracked, and there is a paucity of research. Okay. So, what do the statistics reveal? And I won't go into that except to say they don't reveal very much. Nobody collects statistics on sexual offenses. The only statistics available are the statistics of the judiciary, and the judiciary collects statistics for its own purposes. So what you will see when you go to the annual reports of the judiciary of the Republic of Trinidad and Tobago, they're all online, you would just see number of cases, very little of sexual offenses. You would see 23, for example, in that time period, and the number, the outcomes are not even clear. So sexual offenses have really been relegated to the back burner in the last, say, 20 years, 20 to 30 years. Oh, and I should just add that the conviction rate for sexual offenses is extremely low. So we have no idea of what is happening from the time the report is made. If a charge is laid, how many enter the judicial system, how many are sustained along in the courts, and what happens after. Okay, so go. Right. So I'll skip the statistics on domestic violence because they follow the same line, except to say that the police collect statistics on domestic violence and the judiciary, but again, it's the same. We have no idea of outcomes. The first Domestic Violence Act was introduced in 1991, as you can well imagine. Trinidad and Tobago was the first country in the Commonwealth Caribbean, introducing dedicated domestic violence. It was a very challenging piece of work, and those who were crafting the legislation tried their best, but needless to say, there were many gaps. A subsequent review, improved the legislation significantly, and skip that okay. Go on. So I have just listed the significant ways in which the 1999 Act improved on the 1991 Act, the substantive provisions. The key provisions, however, I recently did a review of the 99 Act for the government of Trinidad and Tobago, and with respect to the substantive provisions, what was found is that there are narrow definitions of visiting relationships. There's a lack of recognition that gender power imbalance plays out in all forms of intimate relationships. There's a lack of recognition that controlling, coercive, or threatening behavior are dangerous manifestations of male power and can have dreadful consequences. There's also a lack of recognition of the behavioral, psychological, and psychiatric impact on domestic violence of children, even where they are not direct victims. Okay, so but what was most interesting, and I would conclude more about here, was that there were a number of participants in the public consultations and in the focus group discussions that we had in order to review the Act. They were concerned that the substantive provisions were strengthened, but that was the least of their focus. Their focus was that the law was not being adequately implemented. So that even if we were to strengthen the domestic violence legislation with all of the findings, examining the substantive provisions, it is not going to make much of a difference to the victims. And this is again based on what our understanding of masculinities is. So they reported inadequate police response, repeated court adjournments, lack of support, hostile court environment, and very quickly, right, so how are we going therefore to craft a law as a tool to address gender-based violence, including domestic violence? Can we do that, or do we have to do it together with intersectionalities, as Levi was talking, where all these masculinities are inserted? And so I just want to say that the statistics are woefully inadequate. They don't tell us anything. The research, we've had two important pieces of research, one by Mary Creaky, published in 1994, and another very important study by Mindy Lazarus Black, who published several papers as well as a book entitled Everyday Harm, Domestic Violence, Court Rights, and Cultures of Reconciliation, research that she did in Trinidad and Tobago on the implementation of the 1991 Act. She found that most applications were made by women against men. She found that the vast majority of applications were dismissed, as Mary Creaky found. Go on, sorry. She found that the reasons for abandoning or withdrawal of cases, these were the reasons: reconciliation, persuaded by friends, families, intimidated or threatened by partners, disillusionment with the court process because of the repeated adjournments, lack of evidence. This is the last slide. Yeah, okay, well, leave it on the last slide.
Thank you very much, Gaietry, particularly for rushing through it. But let me say that once the discussion starts, anything that you feel that you've left out and having had to force your wealth of experience into 10 minutes will come out in conversation. But we need to be able to start the dialogue. That's very important.